Welcome back to part 2 with Judge Goethals. If you didn't see the first one, please go back and watch that because this is a continuation of that great conversation. Speaking of the Decry case, how long did that case last in front of you?
Scott Dekraai on October 12th, 2011, had virtually no criminal record. He was in the middle of an ugly divorce. Mm-hmm. He had gone to LA County Court a few days before that. He and his wife, his estranged wife, were not getting along. The judge threatened to take his son away from him. Apparently, I have heard since. I wasn't there, so I don't know. Mm-hmm. And he was fed up, and he decided to end the consternation between himself and his estranged wife involving his son. He sat in his home that morning in Huntington Beach, decided that he was going to end all of the litigation involving custody. He loaded 3 handguns, 2 semi-automatics, and a revolver. He got in his pickup truck. He brought with him his bulletproof vest. He drove to the Salon Meritage just off Pacific Coast Highway in Seal Beach. Just before noontime, he entered through a side door, and he started shooting. At the end of his 2-minute spree, he had shot 9 people. 8 of them died. 1 miraculously survived. He was captured without really resisting a half-mile away. He made an incriminating statement to the officer who stopped him, who bagged his hands. They took him back to the Seal Beach Police Department. He confessed after being advised. They seized the murder weapons out of his truck. They had about 50 living witnesses, eyewitnesses who knew him because this was a small salon, and so everybody knew each other. They knew him. They had 50 eyewitnesses who could identify him. They seized the murder weapons from him. He made a spontaneous inculpatory statement when he was arrested, and then he confessed on videotape. Sounds like a pretty good case, doesn't it?
Doesn't it? Yeah.
Well, that case resulted, I got assigned that case. People were seeking the death penalty. They made their first appearance in my courtroom in late January, I think. I might have the years. How could I not remember? I think it was 2011. Maybe it was 2012. They made their first appearance after he was indicted by the Orange County Grand Jury in January of the following year, so say 2012. And that case remained in my courtroom involved in intensive litigation for about 5 years.
Oh, 5 years. Wow.
But we started slow because for about a year, nothing happened. And then we had a very volatile hearing at which I made a ruling ordering discovery from the DA's office, which they did not agree with, but they didn't appeal. So I didn't see him for about a year. The next time they came back, Scott Sanders, the deputy public defender assigned to the case, one of the all-time true believers in public defender history, who I didn't know at all when this started, and now I know very well, filed a motion. I came back to my chambers one Friday afternoon in late January.
Wait, wasn't that motion like 500 pages?
The motion itself was in a 3-ring binder that was about that thick. It was 506 pages long, and a lot of rambling going on in that. I've made fun of Mr. Sanders many times about the rambling, but the motion was 506 pages. Filed along with the motion were over 30 binders of exhibits, also big 3-ring, 3-inch binders. So the motion and the original initial supporting papers were about 20,000 pages.
Wow.
Which I discovered one afternoon when I came back to my chambers after taking a long noontime run. And that launched us into hearings which lasted for about 3 years.
Yeah, I remember that.
That's the case I alluded to earlier, that once it got rolling, it became known nationally as the Orange County Snitch Scandal. All the local newspapers beat it to death. My courtroom was full of reporters every day for years. 60 Minutes finally did a story on it. Anyway. It is still generating a lot of publicity. I've written a book about it.
Oh, you did? What's the book called?
It's called Inmate F.
Really?
Inside America's Greatest Snitch Scandal.
Is it published?
It is not published yet.
When's it coming out?
Well, I'm in the process. I just kind of finished it, and I'm trying to sell it, frankly.
Somebody will buy that. Are you kidding?
Well, you would think, and it's a lot of things are happening with it. Mm-hmm. The Orange County lawyer which I'm surprised you don't, you being the involved lawyer you are, the Orange County Lawyer is the Orange County Bar's monthly publication, and it's a very nice glossy magazine that they publish here and send all the members, and judges get it. And the editor, now 6 or 8 months ago, called me and said, I hear you wrote a book about Decry. And I said, yeah, I did. How'd you hear that? And I forget how she heard. She said, would you be interested in letting us run an excerpt from the book? I said, sure. I said, if you're really interested, I said, how are we going to decide? Because the book is 60,000 words, and which is kind of what a book's supposed to be. Mm-hmm. And I said, how many words do you want? She said, 2,500. And I said, well, who's going to decide? And she said, you are. You send us what you want, what you'd like us. So I looked at it, and I sent them 2,500 words, and a couple months ago they published it. And it came out really good. It was in the magazine.
What were you discussing?
I did the first 3 chapters. Kind of set the scene, and at the end of, I think it's the 3rd chapter, the case has just been assigned to my courtroom. The first chapter is taken from something that happened in court to try to grab your attention. The second chapter is sort of the murders themselves, all relatively short. The 3rd chapter is the first appearance in my courtroom, sort of setting the stage where we are now. And then I skipped and I went to another chapter, which Mr. Decry, not surprisingly to me at all. I kind of saw this coming, but it shocked everybody else. Mr. Decry, after we had been in the first hearing for 6 weeks or so, and the hearing was not going that well for the people, frankly, he pled guilty. One day, Scott Sanders announced in the middle of, at the end of a day after a long hearing, the shadows were drawing long. I had one of the only courtrooms in the building that has a window. Yeah. And you could look out and you could see the sun setting over the ocean. The sun was setting, and Mr. Sanders, and I have some of the transcripts, so it's verbatim. He announces that Mr. Decry wants to plead guilty to, in a capital murder with no deal, he wants to plead guilty to 8 murders, 8 first-degree murders, an attempted murder with premeditation and deliberation, and admit the multiple murder special circumstance with no deal. And that, I mean, I had kind of been expecting that because he didn't have a defense, obviously, based on what I said earlier. I mean, it was overwhelming.
Yeah.
And Scott Sanders, who is one of the best lawyers I have ever
He's amazing, isn't he?
He is amazing. And also one of the gutsiest. That was an incredibly gutsy call. That if things hadn't turned out for him the way they did, I'm sure that people would have criticized him. And some people did criticize him either at the time. How can you just roll over on your client? People did criticize him. Yeah. But he, a week later, so I said, the hearings were Monday through Thursday every week, and Fridays I would do other things. So I said, when do you want to do this? And he up front, he said, at the convenience of all the victims and the people, I haven't told anybody. So I looked at him and I said, how about this Friday? Can you be ready this Friday? And I looked at the 2 prosecutors who were very experienced prosecutors. Their jaws were on the table. And I said, can you guys be here on Friday to see if there's going to be a change in plea? And they go, sure, I guess. They're like in shock. So that Friday, so that's the end of the excerpt, is he does plead guilty. And so I spent an hour and a half talking to Mr. Decry, accepting his guilty pleas and making sure he understood that my only options at that point, once he pled guilty and admitted the special circumstance, he was going to die in prison one way or the other. He was either going to get life without parole, or I was going to sentence him to death, and he understood that. And
so the decision was on you for.
Well, that didn't end the case. People are surprised. Read the book; you'll find out what happened. But we still had another 2 years of hearings. Eventually, I kicked the district attorney, the entire district attorney's office from Orange County. More than 250 prosecutors. I recused the whole office.
What was the reason for the recusal?
Well, it's a long story, but eventually I made a finding, a lengthy finding. I wrote long rulings, like appellate opinions, and I explained at the end of the first part of the hearing, I found that there had been misconduct, but I declined to kick the DA's office off to recuse them because I said that I was still confident that Mr. Recusal could get his act together and bring this case home fairly, which is, what you have to find. And I believed it. I didn't just stumble into that conclusion. I thought that was true. And then I thought we would go on. He had already pled guilty at this point, so what we were going to have was a penalty trial. That's what I anticipated. That's what everybody sort of anticipated. We would have a penalty trial, and just the way you do in capital cases. I won't bore everybody to explain how that works, but maybe you've seen it in the movies or on TV. Both sides get to put on evidence of aggravation and mitigation. And I figured that's where we were going, and everybody did. And then after we finished the first hearing, a couple months later, I was giving them all time to gear up again. All the lawyers show up in my courtroom again, Mr. Sanders and the prosecutors, and said, Mr. Sanders says, I've got new evidence showing that some of the findings you made were mistaken and that some of the prosecutors and cops and people who testified at the first hearing testified falsely.
Oh, wow.
And I just went, oh, my God, because that was a really painful. That first hearing that lasted for 5 months, and it was pretty painful. And I looked at Mr. Sanders and I said, we are not having another hearing. And then much to my surprise, to this day I'm shocked, the prosecutor said, we want to have another hearing too. We want to clear our names, or words to that effect. And so I said, you got to be kidding. So we launched into a second hearing, and at the second hearing, things went even worse for the district attorney. And at the end of that long hearing, which lasted for months, I made even more specific findings, and I found that some people had lied. And I said, I'm not confident that the district attorney's office can fairly prosecute this case. Cops and district attorneys have lied. And it's a capital offense, the biggest mass murder in the history of this large county, the sixth or seventh largest county in America, with 250 prosecutors and 3.5 million people, a larger population than over half of the states in the union. They just can't, they can't be fair, so I kicked them off. But they said, well, we're going to immediately appeal. I said, okay, have at it. I might be wrong. Nobody's ever done this before, so I could be wrong. So we delayed, and they took an appeal to the 4th District, which I, some years later, ended up sitting on. And in a unanimous opinion, a year later, the Court of Appeal found that I was right.
Wow.
And so the case came back to me again. Now the district attorney's office is officially kicked off. The attorney general, I said, Kamala Harris, you and your office got to take over. And she did. She never appeared, but she has a couple of trial lawyers in her office, and they came and they jumped into a very, very difficult position because we'd already been in hearings for a couple of years.
Yeah. I
had already made some really adverse findings about what was going on. The media was all over it by now. And so we started a third hearing. And at the end of the third hearing, things just kept progressively getting worse and worse and worse. And I as a sanction for the ongoing misconduct, which I made clear I did not attribute to the specific deputies, attorney general, who I thought were very honorable, worked their brains out to try to be fair. But I thought overlooked a few things that maybe they should have been a little more sensitive to. I said, as the only sanction I have left really is to take the death penalty off the table. So I removed the death penalty. And I said, now all that's left, that I don't have any more options. So I said I'm going to set it for trial for sentencing in 30 days, understanding that all the victims have a right to come in and do victim impact. And I said, I want them all to be here. This is a terrible crime. And so in September of 2007, we had a long, difficult victim impact hearing. And amazingly enough, to this day, it's amazing. There were 8 innocent people who had died, and a 9th who was shot, and miraculously her daughter was killed. She was there having her hair done by her daughter, who was a hairdresser at the salon. And her daughter did not survive, but she did miraculously survive. When they came in, much to my amazement. To this day, it's amazing. About half of the people actually thanked me. They said they were all still, they had no forgiveness in their hearts for Mr. Decry, nor did I expect them to. He killed their loved ones in cold blood. And he called them collateral damage. He wanted to kill his wife, and he wanted to kill her best friend. And the rest of them he later called collateral damage. Pretty cold. Anyway, but a lot of them, half of these nice people, somewhere in the midst of their tears and their anger, they thanked me and said, we couldn't believe that this could happen, that there could be such corruption in law enforcement, and you forced them, you forced these hearings that obviously were painful to you and everybody else, but it showcased this, and hopefully something better will come out of this. Yeah. And so half of them said that. The other half said, are you nuts? This guy should be on death row. And I didn't argue with him. But it was what it was. And my mantra for a long time, this sounds corny, everybody laughs when I say this, but my mantra for many years as a judge and as a justice on the Court of Appeal is we're going to follow the evidence to find the truth. And I said that from the bench a number of times. When people, this hearing lasted for 5 years, and it generated a lot of emotion from between the lawyers and between the survivors and friends. And the cops were mad at me, and the DA's office said they were going to run me out of the county.
How did you deal with the stress of that? I know you run. Do you still run?
I can't run anymore.
Oh.
I was a veteran runner. I ran thousands of miles, and I got into the routine. I would run every day at noon. It was a perfect time. I didn't have to get up early. I hate running in the morning, and when I come home at night, there's other things I'd rather do, be with my family and my lovely wife and stuff, or just do other things. But one of the nice things about being a judge is, you can take you take an hour in the middle of the day because the jurors need a break and the lawyers need time. And I remembered, you work through the lunch hour as a lawyer because now you got to gear up for the afternoon. And so you take an hour and a half, really, is what the typical break is. And there was a janitorial locker room in the basement of the main courthouse, which I discovered like the first day I was there.
That's funny.
And as a young prosecutor, I met an old prosecutor named Dave Carter, who's now a federal district court judge.
Love Judge Carter.
And he and I are still very close. And I met him, and he had the job that I had 10 years later. He was at the top of the pyramid as in charge of the homicide unit. He was still a DA.
Oh, okay.
I knew him when he was still in the DA's office.
Oh, wow.
Then he became a judge, but he adopted me, and he and I started running together almost every day when he could. And then we developed a big group, and we'd run. So that's one way. And so, but I got 2 new hips and a new knee now. That's the downside to running thousands of miles. And Carter's got 2 new knees. So eventually your joints wear out. But people have asked me that a lot. I've been interviewed a lot about that case. And I really didn't ever have a hard time sleeping.
Oh.
I'm not going to say it wasn't stressful at times, but I was confident that I was doing what I had to do. And so that didn't stress me out. And even when I never thought it was going to end up where it did. I thought, honestly, when I read Scott Sanders' 506-page motion and I plowed through all 20,000 pages of the exhibits and made notes about it all, which, took a little while to do all that.
Yeah.
And then I read some of it again. I thought we would start this hearing. And the DA went ballistic when I said, well, we got to have a hearing. They said, are you nuts? We don't have to have a hearing. I said, well, how am I supposed to make findings? He is making these very serious allegations of misconduct. He says, these are the facts. Do you want me to just say those aren't the facts? What do you suggest that I do? This is the kind of scenario where a judge hears testimony and makes factual findings based on what you hear in court. How am I going to get there if I don't have a hearing?
What'd they say?
They didn't really they were just outraged that I was sort of legitimizing some of the claims or something. But I could never figure out how I couldn't have a hearing. So I said, we're going to start a hearing on March 18th. I wanted to start it on St. Patrick's Day. I don't know why, but I did. But for some reason, that's why I remember the date. It was the day after St. Patrick's Day in 2013 or something like that. And but I thought, based on everything I read, as I read this, it was just so far-fetched. And I had been in the system for 25 years, and Scott Sanders was saying this stuff went back for decades. It had been going on for a long time. And I had been a prosecutor trying murder cases, and I'd been a defense attorney trying murder cases. And I guess I was too dumb to see it, I guess. I don't think I really was, but I never saw it. And so I just couldn't figure out how this could have been going on. So I thought we'd start, and I thought Scott would call a couple of witnesses, and it would peter out after a week or two. Mm-hmm. But he called his first witness, and the name of the book I wrote is Inmate F, because that's how the guy was identified. The people didn't even want to identify who their informant in the jail was, who claimed, the basis for the hearing was, the people claimed they had a secretly recorded confession from Mr. Dekraai taken when he was in a cell in the jail and he was talking to another inmate. And the other inmate went to the police and said, this guy's confessing to me.
Inmate F?
Inmate F.
Did his name ever come out?
Oh, yeah. And so I thought that whole thing was crazy. I had never heard about an inmate having the wherewithal to record a confession from another inmate in the jail. And again, I knew inmates talk to each other in the jail. I'd seen it as a prosecutor. I'd seen it as a defense attorney. Mm-hmm. I always told my clients as a defense attorney, don't trust anybody, don't talk to anybody, just like I'm sure you do, mm-hmm. because it does happen. Mm-hmm. But I never heard of anything being recorded that way. And when I started, and there was a California Supreme Court case right on point when we had our very first discovery motion, that the California Supreme Court reversed a death verdict because discovery had been denied when this same kind of thing had happened in some county in Northern California. It was right on point as far as I was concerned. Mm-hmm. And I looked at the prosecutors who were very good, experienced prosecutors. I said, that case is right on point. How do I not order discovery? And they were just outraged that I was even thinking about it. Well, I did order the discovery. And the discovery, the people went, once they started ordering the discovery, they filed motions, and they wouldn't even name the inmate. They called him Inmate F. That's where that name came from. And after taking testimony and hearing stuff, I said, well, you got to tell them, you got to give them discovery. And you can't redact it. They got to know who this guy is so they can look at his background and what his motivation might have been to do what he did. Well, it turns out, and the people sort of represented, that this guy was just a citizen informant who happened to be in the right place at the right time to hear a confession from the most notorious inmate in the jail.
They didn't even need that on the case.
And they didn't need it. They explained why they thought this was important, but in hindsight it was not important. But anyway, so they said who he was. When we started the hearing on that March 18th, the first witness that Scott Sanders called was Inmate F, who comes in. He's in jail. He's handcuffed. And his name became a public record. The media was there. They saw him. They heard him. He testified for 3 days. He was somebody who had a very serious criminal background, mm-hmm. and he was working off a beef. He had been convicted. He was looking at a 3 strikes life sentence, and he had been working in the jail for, I forget how many years now, 3 or 4 or 5 years as a federal/local informant. And he had testified, and he had done all kinds of stuff, and he was trying to get consideration to work off a beef because he was looking at a life sentence himself. Mm-hmm. And after that, and he admitted in his 3 days of testimony, he admitted about 90% of these crazy things that Scott Sanders had said. He didn't admit it exactly the way Scott Sanders had framed it, but the substance was he admitted that a lot of this had happened.
Wow.
And at the end of that hearing, at the end of his 3 days, Scott Sanders looks up, and I'm like, holy smoke, this is serious. His second witness that he called was the lead homicide prosecutor sitting next to him at the table. And that just about sent the people into
oh my gosh.
And it was like nobody saw that coming. Well, I completely saw that coming. And they just went ballistic and said they had never heard of this happening. And I volunteered from the bench. I said, well, I hate to tell you, when I was a prosecutor and when I was trying murder cases, I myself recall testifying 2 or 3 times about decisions that I had made, and nobody even objected. I don't remember anybody objecting.
Wow.
I got the public defender's office wanted to call me. I remember on one capital case in particular, and I testified in front of now Justice Eileen Moore, who became my colleague on the Court of Appeal for 7 or 8 years. And I remember vividly testifying about it, and the public defender examining me about decisions I made. And I said, if you have a privilege or some reason or statute that makes you exempt from being called as a witness, I'm not going to let them call you, but I haven't heard anything yet. So they went down and ran around, and they came back up and said, we don't have any statute. We don't think there's a privilege. It's just unfair that I would be called as a witness. And I said, well, there's 2 of you there. The other guy can represent you, or you can get somebody else from your office. So they brought somebody up from their appellate section to represent him. So they had a whole team of prosecutors there. And I said, you got to testify. So he came up and he testified for 2 or 3 days in front of a packed house.
I can imagine.
And I had complete sympathy for him because, I had been him about 20 years ago. He was the head of the homicide unit then. They assigned the case to the person who's supposed to be the best trial lawyer in the office, kind of theoretically. And it was him. And he is a very good trial lawyer. He's a very good lawyer. And he had to admit, ultimately, which I admired him for doing. He didn't at first, but eventually he kind of fell on his sword, admitted he had made some mistakes. And that could not have been easy to do in front of God and country and the media.
Yeah.
And but he did. And so after the first 2 witnesses, the informant and the chief prosecutor, now we're about 2 weeks into the hearing.
This is the hearing that they wanted, the prosecution?
No, this is the very first hearing.
Oh, okay.
This is the first hearing that lasted for months. And anyway, so that's the case. I mean, I had done a lot of kind of cases that received a lot of publicity before that. But that case gave me my 5 minutes of fame. And I think that's the case that caused the governor to think, maybe I should appoint this guy to the Court of Appeal years down the road. It took a long time. It took us, we started, as I said, those hearings in 2013, and they didn't end until 2017.
That's crazy.
Yeah, anyway.
Do you, looking back on that whole case, is there anything you would have done different?
Probably not. Again, I've been asked that question before, and I've had a chance to reflect on it. I regret my first ruling at the end of the first hearing when I didn't kick the DA's office off the case. I said some things then that in hindsight, I think in my own mind, nobody's ever said this to me, but I look a little foolish that I perhaps gave law enforcement too much benefit of the doubt. And don't misunderstand me. I was a prosecutor for 12 years, and those were great times, and I have nothing but great respect for prosecutors and law enforcement who are doing their job legally and ethically. We certainly need them. And most of them are doing that. But this was a funny situation, and I have never asked Scott Sanders, and he and I have become pretty friendly after all this happened, just through one means or another. I've never asked him what he said when he went back to the public defender's office after that first ruling. When I did find misconduct, and I suppressed all those the jail statements, but by at that point, it had gone so poorly for the district attorney, for the people, that they really weren't even contesting that at that point. They knew those statements were going. It was just, the Inmate F was clearly an agent of law enforcement, even though originally they had said he wasn't. Clearly he was. And so they knew those were going. And I made some other findings that of misconduct, but I said, it's so extraordinary to kick an entire district attorney's office out of a case when you got 250 prosecutors. It's one of the biggest prosecutorial offices in America. You can't find one prosecutor who could fairly prosecute this case. And there's a lot of published opinions from the California Supreme Court and lower appellate courts that underscore how difficult and unusual this is. So I just didn't think the record supported me kicking the whole office off. But in hindsight, I probably should have.
At the first hearing? At
the first hearing. But, in terms of feeling that the right result was ultimately reached. I believe in due process. That's not just a phrase to me. I mean, I understand kind of what due process is, and this was a process. And I think, looking back, given kind of the historic nature of this case, it needed to go through the process. And I think perhaps everybody felt better about where we ended up because it was such a painful, long process to get where we ended up.
Yeah.
I probably do too, in hindsight.
It's amazing the effect that had. Because I forget what Inmate F's name was. What's his last name? Because he was involved on the federal side as well. Because I was one of the attorneys.
Fernando Perez, something. It was a Latin name.
Because I think they.
Gosh, how can I not remember?
I know.
That's embarrassing.
It's in your book.
I lived with him. It is in the book. His name's in the book.
Anyways, I was on the Mexican Mafia case where Ojeda was being tried and his alleged girlfriend. I represented the girlfriend. And it was that whole operation. I forget what the name of the operation had, but it took two different routes. Because the U.S. Attorney's Office had it. They decided who they wanted to prosecute federally. That's why I got one of them. The DA's office got everybody else.
Right.
Which I think was.
They cut that. There was a task force operating in the Orange County Jail, clearly, appropriately. It was a joint local federal task force operated by a bunch of Santa Ana PD cops, people from the district attorney's office and the FBI. And they were trying to ferret out or at least determine the extent of the Mexican Mafia's influence in the Orange County Jail. And Inmate F was affiliated with the Mexican Mafia, very active. I don't know how you determine who a real member of the Mexican Mafia is, these prison gangs. But there are a limited number of actual members, as you probably know. But he was very actively involved in the Mexican Mafia. And so during our hearing, at one point, the district attorney's office kind of tried to blame the U.S. Attorney's Office for their discovery failures, saying that, the feds ordered us not to reveal this stuff. And the leader, the head of the local U.S. Attorney's Office on that case, who is now a Superior Court judge herself, she came in, and I can't remember if she was a judge when she testified, but she came over with counsel and testified and said, that's baloney. And I found her very credible. And I know her a little now. I didn't know her at all then. As I say, she's now a Superior Court judge in Orange County.
Yeah, she testified in my trial when she was a judge.
Yeah.
And it was like my turn to question the witness. I'm like, I don't have any questions, because I had to appear in front of her. I'm like,
she was very uncomfortable testifying in my case, but Scott subpoenaed her and called her. And again, I had heard prior testimony from a deputy DA and I think some cops saying, well, we only did what we did because the U.S. attorney ordered us to, and what were we going to do? And she came over and she was the one who was going to make the decision, and she said, that's baloney. That's not what she said exactly, but
right.
A little more formally. But she said that, we never did that. We never told them not to respect their discovery obligations and do what they were supposed to do. And we never told Inmate F to do some of these things that have come out that he did. So
yeah,
it was a very involved case.
It was crazy. I can't wait to read the book. Are you going to do the audio of the book?
Well, I mean, I don't know. I maybe only my grandchildren are ever going to read this book. Maybe it will just be a memoir.
No, I think.
But when people hear about the book, and I've let a few people read it, and they're enthusiastic about it. There's somebody in New York that this story. I'm not the first one. A reporter from New York, I have gotten to know, who won a Pulitzer Prize, has written a 6 or 8 part serialization of the Decry case that appeared in a magazine sometime last year, and I read it. It's an online magazine.
Okay.
And they're shopping around the story to showrunners in New York.
Oh, wow.
And I worked with her. I met with her, and she's a neat, very qualified reporter. And it was very well done, better than my book, obviously. But my book isn't bad. And
I'm sure
and
it's
the
not
insight,
bad.
and I share a lot of stuff in the book, which is the only reason I think this book might. This is not a book sales interview, but You know, it's kind of unusual because I've looked. It's unusual to have a judge to find a book written by the judge who handled the case. There's lots of books written by reporters and stuff like that, but written by the judge who actually handled the case and made the decisions, who kind of explains what his or her thinking was and that kind of stuff. And since I'm retired, I can do that. The case is over, and I can do it. I can talk fairly candidly. There's a few things I probably still wouldn't talk about, but I'm pretty candid in the book, just like I'm trying to be candid with you.
Yeah. Yeah, I can't wait. Do you know when it's going to be out?
I have no idea. It's with right now. It's at a publisher, and it's with an agent in New York. But I've had some rejections already. I've had some initial interest, and then some people think that it's kind of old news now, because it is kind of old news. But it's about how the system operates, and it's more of a systemic, and it's a little bit of a memoir too. From I got to tell people about myself a little bit, so I have some credibility in what I'm doing.
Right.
But I think I don't think it is as time barred as some people have thought. They've expressed some initial interest, and some people think it's a little too niche, a little too inside baseball kind of. This is how the criminal justice system operates. But I think for the right audience, it might be interesting. See, you're interested.
I am
but
interested.
You know me.
That's
but you
true.
Know me.
That's true. I would read it. Now, I just want to cover, you said you're retired, but you're not really retired, right?
I'm not quite totally retired. That's true. I'm doing some private judging.
Right. And what does that involve?
Well, there is a cottage industry, which I have heard about. In fact, I remember when Warren Knight, it started, there are several companies that do this nationally. The first one was called JAMS, which stands for, it's an acronym for Judicial Arbitration
Mediation Service?
And Mediation Services. And it's headquartered, or at least it used to be, here in Orange County. Started here in Orange County. A Superior Court judge 40 years ago named Warren Knight left the bench as a young, well-thought-of judge and decided he was going to start this. And I remember when he did that, everybody thought he was crazy, because everybody thought Warren Knight, who has since passed away, was a really good judge. But he went out and he built an empire. So JAMS is now international.
Wow.
A bunch of my friends work for JAMS. And I talked to them. But there are several other companies also. There's Judicate West, there's Signature, and there's ADR Services. And I talked to all of them when I was thinking about retiring, and I chose ADR Services because it's a little bit more user-friendly. It's not quite as corporate, and I've been very happy. I've been working there since I retired. You do arbitrations, which are like private trials. You do mediations, where you bring the lawyers and the parties together, take the case out of the court system, and based on your wisdom and experience, I got a lot of experience. I'm not sure how much wisdom I share with them, and I try to get them to see where this case probably is going to go. You don't squeeze them. You just try to convince them that perhaps a better way to handle the case would be to settle it. So I've had a lot of success doing that, and I enjoy it. And you can kind of, at ADR Services, they give me a lot of latitude and longitude, and I get to kind of do what I want.
Nice.
I am also Judge Carter, who I mentioned earlier, who's a federal district court judge, called me within a very short time after I retired and asked me to consider helping him on a case that he is handling that has gotten a tremendous amount of notoriety. He is the federal district court judge who is handling the homeless case in Los Angeles City and Los Angeles County. And he needed somebody to be a special master for him on the county side of the case. He had a city master who's terrific. And the county special master had to resign. And so he asked me to consider. My initial reaction was, I am not going to do that. I have no interest in it. It's a gigantic challenge. I'm honored you asked me, but the timing is bad. But Judge Carter is a convincing soul who I've known for almost 50 years. I've always considered him a mentor. And we can talk very candidly to one another. He said, think about it, and I'll tell you why you should do it. And so I started thinking about it, and I talked to my beautiful wife again about it. And as always, she said, do what you think you ought to do. So after thinking about it for a week or two, I called him back and I said, you know what? If I have a lot of experience, we'll see how much wisdom I have, but I think you're right. I think I should do this.
That's awesome.
And so I'm doing that also.
You're busy.
So I'm busy, but I I just came back from several days out in the desert after
Nice.
Easter with some of my kids and grandkids and my
perfect.
beautiful wife, and got a little tan. And so I get to take time off and have some fun. But they pay us kind of embarrassingly on these private judging cases. I'm a little embarrassed.
I've seen those. I work for a firm and I do trials and they do mediations, and I'm like, wow.
You've seen the bills, and
I've
so
seen
you
the
can
bills.
see it is
It's good, though.
flattering, but you got to earn your money, I think, and so I really try to earn my money.
Yeah.
If they're going to pay me those kinds of fees, I get them where they want to go. They want to settle, and I did those. It had started back when I was still a lawyer, and I remember I never did an arbitration that I can remember, but I did a lot of mediations, and actually maybe I did some arbitrations. And there is value to it. You take it out of the system, you get the people where they should be going faster, even though you pay the neutral. They call us neutrals, not private judges. And you get them where they're supposed to go faster and more efficiently and hopefully fairly. You can't make anybody do anything. That's what I say at the beginning of every mediation. I used to be able, as a judge and a justice, I could tell people what they were supposed to do and they had to do it. I said, I don't have any power anymore. That's when I said earlier, sometimes I discourage people from calling me judge.
Yeah.
They still do it.
Yeah.
But, I'm not a judge anymore. I'm not a justice. But most people still call me judge or justice
Yeah.
when
it would
it's
be
in a
weird.
professional setting.
Yeah. I just couldn't do it.
So I find it very rewarding. If I didn't have flexibility, I wouldn't be so anxious to do it. But with the flexibility, I'm working on selling the book. And I've rewritten the book some in response to some notes that some people have given me. I think it's better now than it was. And I still think it's good, but again, only my grandkids may ever read it, but we'll see.
I'll read it.
Okay, I'll let you read it if you want.
I'm sure the people watching will read it too.
Okay.
Well, I think we're at the end of our time. We may have gone over a little bit. I would love to have this keep going on and on because I don't think I got to half of my
I
questions.
told you we
but-
wouldn't. You
I
sent me like a
know.
14-point outline, and then you turned me loose, and I start gabbing, and I
That's all right.
apologize for that. But
Oh, no, that's all right.
you turned me loose.
You're the guest. But I just wanted to thank you for being here, and maybe we'll have you back on if you're willing.
If we sell the book, I'll come back do a reading.
Okay.
How about that?
Yeah,
There you go.
perfect.
Yeah, the first chapter or two are the readable part.
That sounds good.
It's been a pleasure. Thank you for inviting me. This has been fun.
Perfect. We'll see you soon, hopefully.
Okay, thanks.